This video is basically about Article 23 of our Indian Constitution, that is, prohibition of traffic in human beings and bonded labor. What is Article 23? So let's understand with the definition of Article 23. It states that traffic in human beings and the begar and all other similar forms that are connected or concerned with the forced labor are prohibited, and any contravention seen in this provision shall be an offence which will be punishable following the law. Secondly, nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, the state shall not make any discrimination on grounds of any religion, race, caste, class, or any of them. Because if any discrimination is found being made on the grounds of religion, race, caste, sex, class, it will not only be violative of Article 23 but will also be concerning with the issue of Article 15. Next, three common elements which will be found under the category of human trafficking is sex trafficking, forced labor, and debt bondage. Now, let's understand the legislations which were being made in regard to this article. First was Immoral Traffic Prevention Act 1956, which was made in order to prevent human trafficking. This statute penalizes trafficking for commercial sexual exploitation. Also, a major issue concerning here is that it not only involves adults in human trafficking but also children are involved. Second act which was being formulated in order to prevent forced labor, that was Bonded Labor System Abolition Act 1976. It is a practice in which employers take and force their workmen to work for them without any remuneration, that is free of cost. Like you employ a person on a land to work for you, but you are not paying any cost for that work. And if any person was found violating of this act, that person was being punished for 3 years, that is for people rendering bonded labor against their will. Third provision which was made, it was in Indian Penal Code 1860. In IPC section 366 clause A and section 372 prohibits the selling of minors into prostitution and kidnapping respectively. Now, what is the scope of Article 23? It is a well known understood fact that the scope of Article 23 is very wide because it includes many forms of labor, human trafficking in it. Also, it ensures that a person is not forced to do anything involuntary. For example, it forbids a landowner to force a landless to render free services. Now, let's understand main three terms. First is human trafficking, second is begar, and third are other forms. Human trafficking. This refers to the sale and purchase of human beings mostly for the purpose of sexual slavery, forced prostitution, or forced labor. Begar. This is a form of forced labor which refers to forcing a person to work for no remuneration. Third, that was other forms. It includes all other forms in which the person works for a wage less than minimum wages. In this, a person is forced to pay off his debt for inadequate remuneration. Now, there were Constituent Assembly debates in regard to this article, that is Article 23 of our Indian Constitution, and also in regard to Article 17 of our Indian Constitution. There was an argument about this article that where it was claimed in Assembly, it prohibited human trafficking and forced labor that was drafted in Article 17. But the main issue that was it was proposed in addition to this mention in Article 23. The article also makes special mention of Devdasi. Devdasi is basically a term that explains young women's social practice to temples, which amounted to trafficking, in response to which Professor K.T. Shah argued that Devdasi should be mentioned, whereas other members were of the view that the practice of Devdasi cannot be considered and cannot be banned. So Sardar Bhupinder Singh had an opinion that the state must compensate adequately in case of compulsory service, which was rejected. There were three main landmark judgments in regard to Article 23. First one was Bandhua Mukti Morcha versus Union of India, in which Bandhua Mukti Morcha was an organization that was working towards bonded labor. A letter to Justice Bhagwati, from where court treated it as a PIL and the matter was looked into. In this, the court laid down guidelines establishing rules for determining bonded labors and stated that it is totally upon the government of the state to identify, release, and rehabilitate bonded laborers. Second was Sanjeet Roy versus State of Rajasthan. In this case, it was held that the Rajasthan Famine Relief Works Employee Act 1964 is constitutionally invalid as to exclusion of Minimum Wages Act. This means that minimum wages should be paid regardless of whether the person is affected by drought or whether that person is affected. This is essential so that the state does not take unfair advantage of helpless people. Third case was Kahasan Tangluk versus Smriti Sheli. In this, before independence, there was a tradition in Manipur where each of the households was forced to do 1 day's work without any pay, which was upheld as a custom, which cannot be deemed amount to be forced labor in case Miksha versus State of Manipur. But it is said that when a Kulakappa insists on carrying on the custom, it led to forced labor as the villagers had to do it without receiving wages for that work. So let's conclude our video by mentioning some important points that in India the practice of exploiting and infringing the rights of people is still present, and that to on a large scale. Everyone should be paid for their hard work, and it's high time that we should stop this type of exploitation. Thank you. Like, share and subscribe. Thank you for watching our video. Stay connected.